If you at all follow American politics, one of the most controversial decisions that a president can make is assigning a member to the Supreme Court, because the Supreme Court has the final say on how the Constitution and how our laws should be interpreted for the entire country, and also whether any laws passed by Congress or orders passed by the president should be thrown out. And if they make a decision like that, there's no going back. It's very rare and very difficult to change a Supreme Court decision, even if that decision has a very unpopular impact on people's freedoms, people's personal beliefs, things that can have a very immediate and personal impact on your community. So the judicial branch, which covers both state and federal law, will deal with two types of cases, two types of arguments within our legal system. The first type of case is the criminal case. Criminal cases involve people accused of breaking local, state, or federal law. The key component for a criminal case is that someone had to have been arrested. If there's no arrest, then it's not a criminal case. If it's a matter of one individual accusing another individual, or even accusing the government itself of violating the law, of causing harm, causing damage, hurting someone's freedom, then that is a civil case. Cases where there is some dispute over property, relationships, or freedoms. However, because of federalism, we have many rules and laws that only apply to individual states, and we have many rules and laws that come directly from the federal government that the state really isn't responsible for enforcing. So to do that, America has a dual court system. And simply put, that means we have an entire court system that handles state law and an entire court system that handles federal law. Those two court systems each have jurisdiction. That means power or area of authority over all matters of state law in the state court system and federal law in the federal court system. So if someone violates state law but didn't violate any federal or constitutional law, then you will never see the federal Supreme Court. You'll never go to trial at the federal court level, because that would be a dispute that is under the jurisdiction, the power of the state court system. And the opposite is true for federal courts. Federal laws, constitutional laws, are arguments that will only be heard in the federal court system. And both the state and the federal court system have three smaller levels. Those three smaller levels are the district court, the Court of Appeals, and the Supreme Court. The district court at both state and federal level is always your starting point. If you have an argument or dispute that needs to be resolved, you always have to start at the district court. You cannot go to the Court of Appeals or the Supreme Court in state or federal courts unless you've gone to the district court first, because the district court has jurisdiction over the first time a dispute arises. The Court of Appeals would be your next step if you feel that the district court did something wrong. And if you feel that they've done something wrong, you can ask the Court of Appeals or even the Supreme Court to look at that case, to look at that decision and figure out if something was done wrong. Now, if the Court of Appeals or the Supreme Court feels that the original court or agency followed an improper procedure or made some kind of legal mistake during that trial, during that hearing, during that argument, then they can overturn or throw out that decision as if it never happened and replace it with a new revised position, a new revised judgment that will determine if anyone is responsible for causing damages or harm or limiting someone's freedom. Now, the only thing about the Supreme Court at both state and federal level is while you can go to them if you feel that the appeals court did something wrong, the state and the federal Supreme Courts will only do that if they feel that the Constitution was violated. Now, in the state court system, each state has its own state constitution that the state Supreme Court is responsible for interpreting. The Supreme Court at the top of the federal court system, their main job is interpreting the national federal constitution. And the Supreme Court at the top of the federal court system has the power of the judicial branch to check the other two branches of the federal government, the president and Congress. It can do that by reviewing laws or executive actions that people have complained violate their rights, their constitutional rights, and potentially throw out those laws or orders or actions. The Supreme Court will do so if they feel that a law or act of Congress is unconstitutional. And if it does that, that law, that executive order, gets thrown out into the trash can. It no longer applies. No one has to follow it. No one has to read it. It is completely overruled. And because the Supreme Court has such final power to check the power of the president and the Congress, that's why the only way to get onto that Supreme Court is to be nominated by the president and then approved by the Senate. If the president picks someone to be on the Supreme Court and Congress doesn't like them or feels that would be a horrible, horrible, dangerous, scary pick, then they can reject him and tell the president, pick someone else for us to look at. So both the president and Congress are involved on who gets on the Supreme Court, because whoever gets on the Supreme Court is going to have the power to check on them. And there's nothing that Congress or president can do about it once someone's on the Supreme Court. They can't be fired. There's no term limits. They are on for life. And the only way they get removed is if they're physically incapable of even doing their job because of illness or disability, or if it's proven that they've committed some federal crime. So it only makes sense that the president is going to consider a number of factors when he's deciding who would make a good Supreme Court justice or not. Obviously, they want someone with a lot of legal expertise, someone who really understands the law. So it's always going to be someone who's been a lawyer for a long time or someone that's been a judge for a long time. Also, because they have certain beliefs about how the Constitution should be interpreted or not, a president will think about what their party is. Are they someone that usually votes along the lines of the same party they're in? So Republican presidents tend to pick Republican justices, and Democrat presidents tend to pick Democrat judges and lawyers, which goes hand in hand with the third factor, which is overall judicial philosophy. Is this a judge that tends to avoid overturning laws and just trying to tweak or clarify them? Or is it a judge who pretty much throws out any law that he doesn't think is perfect, that he has to review? Those are the three major factors that a president is going to consider before asking Congress to finally approve that individual to become the newest member of the Supreme Court. However, once those members are assigned, it's very difficult to predict how often those judges are going to actually make decisions that line up with the person who nominated them. There have been a number of very surprising, very controversial Supreme Court decisions that some would argue have very much benefited the freedoms and rights of minorities in America, but there has been some cases that many agree have been very harmful to America. One case in particular is the Dred Scott versus Sandford decision. This is known as the greatest disaster that the Supreme Court has ever inflicted upon the nation. This decision declared for all Americans that slaves are not and could not be U.S. citizens. completely overturning a compromise that was made between the North and the South at the time. This was, of course, when we had slavery, and there was a lot of tension between the North and the South, and both wanted to preserve their way of life while also avoiding a war. But after Dred Scott versus Sandford, the Supreme Court had destroyed that compromise, pretty much opening the door for the chain of events that would lead to the Civil War. Now, there's a lot of things and there's a lot of factors and there's a lot of issues that were going on at the time that doesn't make it so simple to just blame the Supreme Court for the Civil War, but many do agree that if that Supreme Court had made a different decision, maybe that war wouldn't have had to have been fought. Maybe it would have anyways, but we do know that for sure it played a huge impact, a huge negative impact on American society over the next few decades. And that's enough for now on the judicial branch of the federal government. If you have any questions, please let me know in class. Thank you.